If you haven't heard, California recently passed a bill called Assembly Bill 5, and it's known as AB5. And what it did was really created a lot of controversy in trucking and cut a lot of jobs of independent contractors. It's a lot of misinformation throughout YouTube about this bill, and there's a belief out there that it's targeting truck drivers. That's not true. Now, if you're affected by this, of course, you're going to feel targeted by it. And you have that right, but the point in this video is for us to understand the facts of the bill so that we can understand why it was put in place. So, first thing first, starting out. AB5 was simply passed to implement a better system for hiring entities to classify workers as either employees or independent contractors. So to understand this, we must first understand the difference between an employee and an independent contractor. If you're an employee, you're entitled to benefits and protection through the state and through the company. You're entitled to the protection of hour and wages law, unemployment insurance, workers' comp, paid family leave, and short-term disability benefits. Also, you are entitled to a union. You can be a part of a union as an employee. You can be backed by all of those laws as an employee. As an independent contractor, you basically just self-employed. You are not backed by those laws, and you're in a different tax category. So what California did was they implemented an ABC test. This ABC test has 3 different prongs: prong A, prong B, prong C. And what this test does is it allows the hiring firm to classify the worker as either or. So let's start with prong A. Prong A is basically the question of if the worker is in control or direction of the hiring firm. And if you're an independent contractor, the hiring firm must be limited to controlling the acceptance or rejection of the work performed. So what this means is, as an independent contractor, you have an assignment, you have a time to do the assignment, and you basically go on your own. And you do that within time, you bring it back, the hiring firm accept or reject the work. That's the first prong. The second prong, prong B, is the prong that made the big difference in independent contractors within trucking, because this prong says that you have to do an outside service from the hiring firm's usual business. So let me explain what that means. A lot of trucking companies hire independent contractors, owner-operators, to do work up under their authority using their DOT number and MC number to perform the same work that the company performs without the independent contractor. So if you're a trucking company and your usual business is to transport goods from A to B, you can't hire on an independent contractor to do that very thing and transport goods from point A to B. You can hire a independent contractor to take care of plumbing or electricity or anything else that need to be done that's outside of your scope of work. That's the second prong of this test. Now, the third prong is questioning if it's an independent business or a trade, which basically means, do you have your own office that you work out of, and are you good with or without this hiring firm that's claiming you to be an independent contractor? So the difference in the law in California is it used to be just A and C. They didn't have it to where you had to be doing work outside of what's usually done within that hiring firm. So that's where the monkey wrench came in for the trucking industry. Now, when this law was passed, when this bill came about, ride share companies like Uber and Lyft, things like that, presented a proposition that was successful that now exempts them from this law. So if you're an Uber driver or Lyft driver, you don't have to worry about this law applying to you. Now, a lot of people had the question of, who does this apply to? This applies if you doing work in the state of California. If your company is based in California, but you're doing work in another state, it don't apply to you. Another thing about it is, if you're currently working for a company that's in California and doing this type of work, but you are still an independent contractor, you as a worker, you're not the one that's gonna get penalized for it. The company gonna get penalized. So you don't have nothing to worry about if you're still under a company, you thinking about yourself personally. But it would be your best bet to get out of that situation, just in case there is something to come after you about it. It is said that California typically is the start of what's going to go on throughout the rest of the country. So if this is the case, then you might want to start to get yourself a plan of whether you're going to go back to company driver or get your own authority and do your own thing, if this comes to your state. So that's the issue with the drivers that's in California right now. All the owner operators that's there without their own authority, they're stuck on, if they go back to a company driver and take a significant pay cut, or if they take on more responsibilities, more expenses, build their own clients, deal with load boards, deal with brokers, and do the whole owner operator thing. So if I were you in another state as an owner operator, it's probably time to start thinking about a good plan for yourself, just in case this thing rolls out and it becomes something that's all over the country.